Good morning and welcome to Law Talks here on 4CRB. Well, selling a property can be stressful enough without unexpected requests from the buyer before settlement. Maybe they ask if they can collect the keys a few days early, move furniture in, organise trades, or even start living there before settlement. It might seem like a harmless favour, but is it? To explain the legal risks, we're joined by Attwood Marshall Lawyers, Senior Associate in Property and Commercial Law, Mieke Elzer. Good morning, Mieke.
Thanks so much for having me. It's great to be back.
Well, when buyers ask for the keys early, what are they actually asking for?
It can actually mean a few different things, and that's where people often get caught out. Sometimes the buyer simply wants early access. That might be to measure rooms, bring in a tradesperson, or organise some quotes before settlement. Other times they're asking for early occupation, where they're actually moving into the property before settlement without taking actual possession. Or the most significant arrangement is early possession, where the buyer effectively takes control of the property before they legally own it. Those three situations carry very different legal consequences, so it's important not to treat every request as if it's the same.
And at what point does a simple request become risky for the seller?
Well, look, while there's an element of risk with allowing any kind of early access, occupation or possession, the moment it becomes overtly risky is where a purchaser starts doing more than you've actually agreed to. So allowing a buyer in for half an hour to measure for curtains is very different from allowing them to store furniture, renovate or move in. The more access you give, the greater the potential for misunderstandings about who's responsible if something goes wrong. That's why even something that seems like a simple favour should be discussed with your lawyer first, so everyone is clear about what's permitted and what's not.
And what can actually go wrong if the buyer starts moving furniture in, arranging trades, or actually living there before settlement?
Quite a lot, unfortunately. Someone could be injured while on the property. Tradespeople could accidentally damage the home. The buyer might identify something they don't like about the property and try to renegotiate the price before settlement, or the buyer might carry out works that the seller never authorised. If those expectations haven't been properly documented, disputes can arise very quickly. The reality is that once the buyer starts treating the property as though it's already theirs, the legal position can become much more complicated.
And what happens if settlement is delayed or it doesn't even happen at all?
That's really where the risks become obvious. If settlement falls over after the buyer has moved in or taken possession, the seller may have to recover possession of the property. There can also be disputes about damage, insurance, improvements made to the property, or money that's been spent before settlements. Those situations can become expensive and stressful very quickly, which is why we generally recommend avoiding early possession unless there's a very good reason to agree to it.
And why is this especially relevant for downsizers or executives or families selling a parent's home?
So those sellers are often already juggling a lot, and a downsizer might have committed to another property, an executor is acting on behalf of the deceased estate, and families are often trying to balance practical issues with emotional ones. In those situations, it's understandable to want to accommodate a buyer if it helps to keep the sale moving, but that's exactly when it's important to pause and make sure everyone understands the legal implications before handing over the keys.
And if a seller is willing to consider early access, what should be documented first?
Everything. The purpose of the access, the date and time the access is allowed, who can attend, whether tradespeople are allowed, whether insurance is in place, and importantly, what happens if settlement is delayed or doesn't proceed. Depending on what's being requested, it may be appropriate to either prepare a license agreement or additional contract terms to properly protect the seller's interest. The key message is that nothing should be left to a verbal understanding.
And if there's one message today you'd like to leave sellers with, a key takeaway, what would it be?
Don't treat early access as a casual favour. What sounds like a practical arrangement can significantly change your legal rights and the risks you're taking. If anything is going to happen before settlement, whether it's access, occupation or possession, it should be properly documented. The safest response is usually, I'll just speak to my lawyer first. And that short conversation can prevent some very expensive problems down the track.
Yeah, some really important points there, Mieke, especially for sellers who might feel pressured from a buyer in the lead up to settlement. So thanks for joining us today.
Thanks for having me.
You've been listening to Law Talks here on 4CRB, which you can hear every Friday morning from 9 o'clock.